Welcome to this edition of the Michigan Landlord Show, where we'll be discussing probably one of the most important topics for landlords, the eviction process.
But before we get going, remember to subscribe to this channel right now so you don't miss the next episode, and click the bell icon notification so you get notifications when the next video posts.
All right. Also, please write a comment below to let us know how we are doing. If you have any topics that you would like us to tackle, please let us know below as well.
I removed that part.
I know, but I said it anyways.
Now, if you're looking to evict a tenant from a residential property, the prudent course of action is always using the judicial process.
The process is not immediate. It can take weeks or even months, but you must use it as Michigan law prohibits self-help eviction, and we all know what that is. We talked about that before.
A landlord is prohibited from entering the rental property unless the entry is permitted by law. Even then, and with very few exceptions, the landlord must not enter by force, but only in a peaceable manner. Peaceable manner.
Peaceable. The district courts and municipal courts have jurisdiction over summary proceedings by a landlord to recover possession of a rental property. Venue is determined by the location of the property.
The summary proceedings are uniform throughout the state, and the State Court Administrator's Office has approved forms. We will post a link below for you to use for the summary proceedings.
Summary proceedings may include more than a landlord's request for possession of the premises. Landlords may also seek a judgment for rent or other money owing under the lease or for damages to the premises.
Recovery of possession through the summary proceedings is in addition to any other legal remedies such as recovering back rent or other damages that you may file in a separate lawsuit.
Most summary proceedings involve actions for non-payment of rent, which require prior notice to the tenant before filing suit.
And in these cases, the landlord first gives the tenant a demand for possession, or what is sometimes called a notice to quit. The notice must state the reason possession is being sought or the tenancy is being terminated.
When serving the written demand for possession on the tenant, you must service it by first-class mail, delivering it personally to the person in possession or a member of his family or household or an employee of suitable age and discretion, with the request that it be delivered to the person in possession.
And I was just going to interject here. A typical practice would be if you serve it to an adult at that location with the direction to serve it and give it to the tenant, that's enough.
Okay. Or even by electronic service, as we talked about before, if electronic service is agreed to in your lease agreement. So that would be email, for example.
Now, each notice has a different waiting period depending on the nature of the violation.
Prior notice to the tenant is not mandated if termination of the lease is brought pursuant to 1. A power to terminate provided in the lease or implied by law, 2. Expiration of a fixed-term lease, or 3. Trespassing.
Now, when a tenant stays in the property after the lease has expired, you can evict them without prior notice. However, if you've been collecting rent after the expiration, the lease automatically converts to a month-to-month lease, and you will have to give the tenant a 30-day notice. After that 30-day notice, no further notice is required before you evict the tenant.
If the tenant causes a serious and continuing health hazard to exist on the premises or causes extensive or serious physical damage to the premises, you can serve them with a 7-day notice to stop, repair the damages, or move out. You have 90 days from learning of the issue to file a complaint.
So make sure you stay on top of those sort of things. Now, if a tenant or a member of the tenant's household causes or threatens to cause physical injury to another person on the landlord's property, then you can serve also a 7-day notice.
If a person is trespassing or takes possession by forcible entry, holds possessions by force after a peaceful entry, or comes into possession by trespassing, without color of title or other possessory interest, a demand for possession or notice to quit is not required.
Okay, in summary, if they show up unannounced and they're not allowed to be there, you don't need to give them a notice.
Thank you, that's much easier to understand.
If the tenant or a member of the household is manufacturing, delivering, or possessing a controlled substance, you may serve a 24-hour notice to quit, unless you're the one doing it with your tenant.
Sometimes that happens, you know. Hey. It is important to remember that you are going to evict a tenant for the manufacture, delivery, possession with intent to deliver, or possession of a controlled substance. You must first have a police report. Once the notice period expires, which is tomorrow for me, you can file a complaint with the district court. Your complaint may be made for possession only or for a money judgment as well as possession.
Now, in most district courts, a hearing date will be set, and if the tenant doesn't appear at the hearing, you will be entitled to a default judgment.
If the tenant appears, he may file an answer, a counterclaim, and a jury demand. Tenants generally favor jury trials while landlords do not.
During the hearing, several defenses are available to the tenant.
In a non-payment action, the tenant may defeat the action by proving that he paid the rent or that there was no duty to pay the rent because the landlord breached an express or implied lease covenant. Most often the breach is addressed as the landlord's failure to make repairs.
If the summary proceedings are based on an alleged termination of a tenancy, the tenant may defeat the action by showing that the tenancy was improperly terminated.
Sometimes, acceptance of rental payments for a time after the termination date stated in the notice to recover possession of the property waives the notice to terminate by leading the tenant to believe that the action has ended.
Now, sometimes accepting rental payments after you've served the notice and or filed the complaint against the tenant can act to nullify both of those things. So when you are taking action to evict the tenant, make sure you don't accept rental payments, even partial or full rental payments apply in this case. They might terminate the entire action and you start over again.
If the case is based on an alleged termination of the tenancy, the court may not restore possession to you if, generally speaking, the tenant establishes that you terminated the tenancy primarily to punish the tenant for seeking to enforce his or her rights under the lease or under some federal, state, or local law.
Some local ordinances prohibit the landlord from leasing residential property unless the municipality has inspected and certified the property. A tenant in a unit that is being rented in violation of a local law may be able to defend against the suit for possession for non-payment of rent, say, by asserting that enforcing the rental provisions of a lease would result in the court actually trying to enforce an illegal contract. So make sure you review your local ordinances prior to leasing any property.
You know, I have a question. Let's say you go to evict a tenant and the judge rules in the favor of the tenant. Should you just continue leasing to them?
Or find another violation.
Okay.
It depends on what you do. You kind of want to throw what I call the the kitchen sink complaint. You throw everything that this tenant has done and violated into the one complaint. That way the judge has very little to grasp onto and rule in favor of the tenant. However, if the judge still rules in favor of the tenant, you're obligated by contract law to still lease to this tenant.
Okay. Good to know. Let's talk about judgment. If it is determined that you as the landlord are entitled to possession, a judgment will be entered against the tenant. Judgments also may award injunction relief to prevent the person in possession from damaging the property or to prevent the person seeking possession from rendering the premises untenable.
Untenable. You could say uninhabitable or unrentable.
Yeah, let's just go back there.
You might have noticed a lot of legalese in this episode. It's always recommended to at least contact an attorney, if not hire an attorney, whenever you have to evict a tenant.
This shit's complicated.
If it is determined that you are entitled to possession, the next step is obtaining an order of eviction, or what the statute calls a writ of restitution.
If the action is based on non-payment for rent, the tenant may redeem the property by paying the judgment within the 10-day redemption period.
And of course, either side may appeal. An order of eviction orders the court officer to evict the defendant and other occupants from the premises.
Once an order of eviction is issued, it is placed in the hands of a court officer or sheriff for enforcement. If the tenants are still in the property, you cannot go into the property yourself and forcibly remove the tenant or change the locks. You must use the court officer or sheriff. If the tenants have vacated voluntarily, you can take possession and change the locks.
All right, so hey guys, thanks for watching today's episode. I hope you learned a lot about the eviction process today. It's very intense. There's a lot of legalese, and I do recommend you at least contact an attorney before you venture into this on your own. If you do have any questions, please comment below, contact Jeff or myself. Our contact information will be available in the channel description.
Make sure to subscribe to this channel right now so you don't miss the next episode, and click on the bell icon to get notifications when new videos post. All right, welcome to this edition of the Michigan Landlord Show, where we'll be discussing probably one of the most important topics of landlords, the eviction process. Security. Am I supposed to say that?
No. Remove security.
The process is not immediate. However, it can take weeks or months. But you must use it as... Wait, hold on. I'm just saying...
It's supposed to be, remove however.
Okay, yeah.
Remove however, just do a comma.
I'm like...
I think I was like mid-thought on something else.
Yeah. And I'm sitting there thinking about it like, that didn't really make sense. If the tenant willfully or negligently causes serious... Okay, let me read through this real quick. The tenant willfully or negligently causes a serious...
You can just say if the tenant causes.
Yeah. If the tenant causes a serious and continuing health hazard to exist on the premises or...
This is legally, so we can remove the willfully and negligently.
Okay,
It just simply say if it causes it.
The police report can either be made by you with a let me start there. So we're ready?
Yep.
If the case is based on alleged termination of the tenancy, the court may not restore possession to you if you, generally speaking... Let me just restart. That was a clusterfuck.